Friends, now we see what are the restrictions on senior advocates prescribed under Advocates Act. That means, basing on that Advocates Act, Bar Council of India prescribed those restrictions. So let us see what are the restrictions placed by Bar Council of India basing on sections in Advocates Act. You see, section 16 and 16 and 49(1)(g) of the Act. Act means Advocates Act. So basing on this Act, Bar Council of India framed some rules. So what are the rules? Senior advocates, you know that a certain class of advocates will be designated as senior advocates basing on their knowledge, experience, etc. So designated senior advocates, these are called designated senior advocates. Normally we may hear senior advocates, the word senior advocates. Suppose if any advocate having some standing, certain period of standing, we use it to call him a senior advocate. But designated senior advocates means Act prescribes that classification. So these designated senior advocates are having certain restrictions. What are those restrictions? So Section 30 of the Advocates Act, we know that Section 30 provides where, see, regarding place of practice. So regarding this, while they are practicing, senior advocates are having some restrictions. What are those? Come to they are having certain, not one or two, more than. Now come to what are those? What are those restrictions? Yes. See, what? A. According to subclass A, a senior advocate shall not file a wakalatnama or act in any court or tribunal or before any person or other authority mentioned in Section 30 of the Act. Incidentally, Section 30 is here. So we have to look into the what is Section 30 just for 1 second. The learning tactics of the law is that whenever one section, one act or one clause have been mentioned coincidentally in another part, we have to look into the verbatim or at least what is the essence of the a particular section. So what is Section 30 says? Right of practice So, right of advocates to practice. Section 30 deals with our right of advocates to practice. Where he can do practice. So, normally he shall be entered. Every advocate whose name is entered in the state roll shall be entitled as of right of practice throughout the territories to which this act extends. So, the total area of the extension of the act in all courts including the Supreme Court. So, from the beginning itself it says all advocates are entitled to practice including Supreme Court. And before any tribunal or person legally authorized to take evidence, that is one. So, before any tribunal or person legally authorized to take evidence, and before any other authority or person before whom such advocate is by under any law for the time being in force entitled to practice. So, that is, there are a number of case law disputes on section 30, Family Court Act, all those are there, but we don't want to go into the those matters. We are confining here only designated senior advocates and their restrictions. So, here a senior advocate shall not file a wakalatnama. So, this is first restriction. In his name, he cannot file wakalatnama. That means what? Other than senior advocate, somebody will file, some advocate will file wakalatnama. On his behalf, senior advocate will argue. So, that is one restriction. Next, he shall not act in any court or tribunal or before any, so on, so section 30. So, number 2 restriction is he shall not act in any court. Number 1, he shall not file wakalatnama. Number 2, he shall not act. That is, what is the meaning of act? Given in explanation. So, what is the meaning of to act? To file an appearance or any pleading. So, filing of an appearance, filing of any pleading, filing of any application, all these are called to act. Or another meaning is to do any act other than pleading required or authorized by law to be done by party in such court. So, to act means to do any act other than pleadings required or authorized by law. Even pleadings keep apart the pleadings, keep aside of these pleadings. Other acts also come under the meaning of two acts. So, this is meaning of act. So, senior advocate shall not file wakalatnama, shall not act. This is first A. Okay, then come to other restrictions mentioned in other subclasses. We can find them here. Now we have seen A. Now go to B. What B says? A senior advocate shall not appear without an advocate on record in the Supreme Court. We know that there is a system of advocate on record system in Supreme Court. In Supreme Court, a senior advocate. So, a senior advocate shall not appear without an advocate on record in the Supreme Court. So, assistance. Senior advocate should assisted by AOR in Supreme Court or any other advocate who's an advocate in Part 2 of the state rule. So, whose name is entered in the Part 2 of state rule is called an advocate. That is the definition. Other than Supreme Court, advocate in Part 2. Advocate in Part 2 of state rule. Other than Supreme Court. In Supreme Court, AOR. So, Clause B deals with assistance to the AOR. Senior advocate. Assistance to the senior advocate. So, without assistance, senior advocate shall not appear. That is the another restriction. Now, in this B, Clause B, the two restrictions are there. Now, we dealt B Clause 1. Next, Clause 2. This deals with a situation of a designated senior advocate and the position of a senior advocate before he designated as a senior. We know that all advocates doing by practice only during course of time, they will be designated as a senior advocate basing on their skill, knowledge, legal expertise and other things. Before he is designated as a senior advocate, normally he files some cases. Then what is the position of such cases, those cases? So, where a senior advocate has been engaged prior to the coming into force of the rules in this chapter, that means what? Before he is designated as a senior advocate, he was engaged. Before he is designated as a senior advocate, he has been engaged. Then what? He shall not continue thereafter. So, once designated, he shall not continue thereafter unless an advocate in Part 2 of the state rule is engaged along with him. So, before designation of senior advocate, he filed Wakalatnama and that files are pending. Now, what happened? He is designated as a senior advocate. So, what to do? In his place, some other advocate in Part 2 of the state rule has to file Wakalatnama and on his behalf he has to act. That is previous. What is the position of previous files of a senior advocate before he is designated as the senior advocate? That situation has been dealt by Clause B, Section B, Subsection B, Clause 2. Provided that a senior advocate may continue to appear without an advocate in Part 2 of the state in case, this is an exemption, in which he had been briefed to appear for prosecution or the defense in a criminal case. This is an exemption. If he was so briefed before he is designated as a senior advocate or before coming into operation of these rules. So, this is an exemption. Come to C. The senior advocate shall not accept instructions to draft pleading or affidavits. He shall not advise on evidence or to do any drafting work of an analogous kind in any court, tribunal, before any person, or undertake conveyancing work of any kind whatsoever. So here, that means what? This clarification will come after this sentence. This restriction, however, shall not extend to settling any such matter as aforesaid in consultation with an advocate in part 2. So, what is the meaning? He shall not accept instructions to draft pleading or affidavits or advise on evidence or to do any drafting work of an analogous kind. Analogous means similar kind, parallel kind in any court. So, what is this meaning? He should not do unless it's in consultation with an advocate in part 2 of the state rule. That is C. Come to C. He shall free to make concessions or give undertaking in the course of arguments on behalf of his clients or instructions. So here, up to now, we discussed what he cannot do. Here, what he can. What he can, on the instructions of his client, he give concessions. What is the meaning of concessions? That means any matter is going before the court regarding compromise with the other party, or any reducing of the rights of some of the rights or some of the quantum of eligible amount on behalf of his client. All this can be given at the instructions of his client only, or that means instructions from junior advocate only. So, normally, while the matters are going before the court may ask the lawyers, can you give any concession? Concession means any reduction or size of their right or quantum or any particular aspect related to that case when compared with the other parties of the case. So that can be given by senior advocate. He free to make such concessions or undertakings. We know that undertakings, while passing order, the court may ask some undertakings from the parties before the case. Then on behalf of the junior advocate, after receiving instructions from junior advocate, senior can give. Next. Senior advocate shall not accept directly from a client any brief or instructions to appear in any court, tribunal or before any person, authorities in India. So, senior advocate shall not directly accept any brief. He only has to accept brief through junior advocate. That is the meaning. D. Next, come to E. A senior advocate who had acted an advocate, that means junior, in a case, shall not, after he has been designated as a senior advocate, advise on grounds of appeal in court of appeal or in the Supreme Court, except with an advocate as aforesaid. Suppose senior advocate acted as an advocate, that means only other than senior advocate he has acted. something happened about that case. Meanwhile, he has been designated as a senior advocate. Then what is the position of the case of the lower court? He can appear, but through an advocate. Suppose in district court, suppose in a high court, single bench, he argued one case. At that time, he is not being designated as a senior advocate. Then he is only advocate. After concluding this case before the single bench, he has been designated as senior advocate. But single bench given order against to this advocate, then he has to prefer appeal before the division bench. In such a situation, can this advocate appear who has been designated as a senior advocate? He can, but through an advocate, junior advocate. That is the meaning of this subsection E. Next, F. A senior advocate may, in recognition of the services rendered by an advocate in part 2 of the state role, that means junior advocates, pay him fees which he considers reasonable. So, senior advocate, designated senior advocate, may pay fees to the junior advocates, the fees which he considers reasonable. So, these are the restrictions placed on senior advocates by Bar Council of India rules. In Supreme Court, some other restrictions are there. Those are different. Of course, similar but different.